Morning, Your Honors. I'm Klein Preston. Excuse me, I've got some water here in case I just getting over the flu. I start coughing, I might need some of this. Excuse me. I'm Klein Preston of the National Bar. I represent the Heatleys in this matter. I'd like to reserve 5 minutes, please. Your Honors, this is an appeal as of right from the Putnam County Court from a grant of a motion for summary judgment. And on appeal, we respectfully submit that the Chancellor made an error in the application of certain standards in this case. Number one, even if all the Rule 56.03 statements of the movement, Ms. Gaither, were admitted or undisputed in this case, the facts are insufficient to shift the burden, support her claim, and shift the burden to the Heatleys to even respond. In addition to that, the court improperly shifted the burden to, in his opinion, or its opinion rather, to the Heatleys, and said that the Heatleys didn't prove causation and damages and some other aspects of nuisance. In this case, however, Your Honors, none of those factors were actually proven or negated by the movement, Ms. Gaither. None of the elements of nuisance were disproven, and no defenses were proven at the trial court, and we respectfully submit that it was error for the Chancellor to have ruled that way. Whether you applied the standard in Rye or whether you applied the old standard under Byrd v. Hall, it was error respectfully for the trial court to have awarded summary judgment in this case.
Which are you appealing all claims, or are you appealing just the nuisance?
Just the nuisance, Your Honor.
Just the nuisance claim.
Just the nuisance as to Miss Gaither. Yes, Your Honor. At the end of the day, based on the record at the trial court, there was a dispute as to whether the condition still existed, the nuisance condition on the Heatley property, as of the filing of this motion for summary judgment, which was in 2014. This dispute started in 2013. It's already come up to the Court of Appeals once, and there was a decision by a different panel in December of 2018 about it. It was remanded, and the case went back to the trial court. There was an additional claim filed, which was a nuisance claim, and that's an ongoing tort. This continues today based on the testimony of Mr. Heatley. The condition has not been remedied. And based on that, because it is an ongoing tort, and the proof that was submitted at the trial court by Ms. Gaither was insufficient to negate any of the elements of the nuisance, because we have the testimony of Mr. Heatley, and the defense that was raised essentially by Ms. Gaither was that she had no knowledge of the condition or the cause or any of the other factors. But the proof that she submits to establish that is wanting in a couple of respects. She states that her knowledge was with respect to the actions taken by Gaithers. She doesn't mention Generation Gaithers, which was the entity to which, out of the divorce between she and her husband David Gaither, the property was titled, which occurred in 2017. Here we are in 2025. This condition has persisted, and one thing is consistent, and the record does reflect that Ms. Gaither became an owner of this property in 2011. Okay, the record is replete with the facts that initially, once they learned of the condition, the septic tank that was on my client's property that originated, this used to be one piece of property. I think it's important to keep this in mind. This was one piece of property that was partitioned, and so into two pieces of property. The Heatley property, excuse me, is the subservient property on which the septic system that served the Gaither property sits. And when the problem with the septic system and the contamination from human feces and other contaminants were discovered in 2013, they did attempt to remedy it. The remedy was insufficient. During this entire period of time, and this is all in the record, during this entire period of time, Ms. Gaither was either a direct owner or an indirect owner. She was either an owner with her husband, David Gaither, beginning in 2011, or she was an owner by her ownership vicariously as a shareholder in Gaithers, and then a 100% owner of Generations Gaithers, which occurred in 2017 as a result of the parties' divorce. And so during the entire time, she was involved, had knowledge of the condition based on my client's testimony at the trial level through his affidavit was insufficient. The remedy was, and the condition still persists. And frankly, Your Honor, it was error on the trial court to grant summary judgment with so many facts, material facts in dispute. And that's a pretty isolated issue. It's not as I guess, interesting as the municipality constitutional issue, but this is just a standard summary judgment issue that
What are the disputed material facts you say that exist?
well, they claimed they're disputed, first of all, as to whether the condition still persists, but they provided nothing in Mr. Heatley filed, or the Heatleys filed, their own Rule 5603 statements. And the first one in there is that the nuisance condition still persists. They challenged that, but without citing anything to the record. So you could say it's disputed, but even if it's not, it's undisputed. We respectfully submit, and so therefore that would weigh in the Heatley's favor and be a prohibition against granting summary judgment. Then the last statement, which I believe is number 14 in our Rule 5603, establishes that Ms. Gaither was 100% owner of Generations Gaithers beginning in 2017, and she was in total control of that entity, and the condition still persists, and it has not been remedied. They took some efforts.
Is that the disputed fact you say that essentially exist, is that the nuisance conditions still persist?
That's the primary one, yes, Your Honor, and has persisted since 2013, and it continues today. And that issue, the chancellor improperly, respectfully, shifted the burden to prematurely, frankly, on the Heatleys to show and prove all the elements when none of the defenses or negation of any of the elements of a nuisance claim were established by the movement, in this case, Ms. Gaither. And so there are material issues in dispute, and respectfully, we would ask that Your Honors remand this case to the trial court.
So Appelese files a motion for summary judgment, and they say, we've capped this line, we've done whatever we've stopped, whatever we were required to do to stop this from occurring, correct?
Well, with a caveat. They say we took efforts. They say, yes, we capped it. And Mr. Heatley says in his affidavit, but they didn't do anything with the leach lines. The water continues to flow, and he still has the same condition. And the septic tank remains on his property. There is no proof in the record to say that capping it stopped the issue, nor that the condition still remains arising from the actual septic tank that is on the property. That is not determined, and was not submitted, no proof submitted by the...
Who owns the septic tank that's on the property?
Well, now, it would be I guess it would be the Heatleys own it now. But for...
So anything arising from what may be occurring with that septic tank now would be Mr. Heatley's concern?
Your Honor, no, because the condition was created by the Gaithers. This served only them, not him. It only served their property. He has a separate system.
Was that issue discussed at summary judgment?
It was not.
Okay.
It was not raised as an issue by either side because it was understood that this septic tank was served, that it served the Gaithers only.
Okay, thank you.
Thank you, Your Honor.
If it please the court, I'm Douglas Dunn of the Knox County Bar, here on behalf of Patricia Gaither, a defendant in this case. Let me just state that we are here asking the court to affirm the trial court's grant of summary judgment. And let me just address one or two of the points that have been raised in the last few minutes. This issue is here simply on whether Ms. Gaither, that defendant, did anything to create or in any way damage the Heatleys. This case, like many cases, has multiple defendants. And at some point in a case, to prevail, a plaintiff has to establish what each individual defendant did to have liability. And throughout this case, and these claims have been pending since they arose in 2013, Mr. Heatley's argument has always been, these defendants are doing this, or these defendants did that, or these defendants failed to do that. At this point, Ms. Gaither, based on all the discovery, filed a motion to say, you don't have any proof that I did anything to create liability. I will concede with this court the issues of whether the plaintiffs have been damaged or the extent to which they've been damaged or how they've been damaged, that is disputed. And there's no question about that. If the case had to go to trial, that's going to be disputed. At this point, Ms. Gaither says, I didn't have anything to do with that. I had no knowledge. I was not involved. And that's what the facts in the record show, and those facts are undisputed. And that's what the trial court relied on here, is what did she do? How did she do this? And the answer is there was nothing. And the court asked about the undisputed facts. The undisputed facts are this, and the proof that was submitted was this. Ms. Gaither submitted a lot of affidavits and items related to damages and that there's not ongoing damage from the use of this tank. But she also submitted this. She submitted an affidavit, certainly from her, that she had no involvement with Gaither's Inc., which was the company that was run by her husband, David. Gaither's Inc. was the company that remodeled this property to be used as a group home or as an adult residential facility pursuant to requirements of the Tennessee Department of Mental Health. The house was remodeled to meet those requirements. It was licensed by the department to Gaither's Inc. to run the property, and they ran the property and were operating the property at the time and when the discovery of this tank occurred. Nobody knew about it beforehand. And Ms. Gaither, in her affidavit, said she was, in fact, a co-owner. David Gaither and Patricia Gaither, as tenants by the entireties, purchased this property on May the 11th, May in 2011. And it was done for the purpose of remodeling this facility and running this facility. David Gaither was going to do that in his role at Gaither's. She had no role in Gaither's. She didn't work there. She didn't make any decisions. She says that she and David Gaither were separated as of March of 2013. She was shut out. In fact, she says in her deposition that Mr. Heatley introduced in his response, she says, he kept me out, he didn't want me to know anything about it. So she was out. She was a co-owner. But with regard to the discovery of the tank, remediation, Mr. Heatley dealt with David Gaither. The affidavits are clear. There's affidavits that she submitted from the Tennessee Department of Environment and Conservation talking about dealing with the property and the remediation. She had nothing to do with it. So she got her affidavit. That is not disputed. Nobody, Mr. Heatley cannot point to anything and say, well, you were in charge, you knew, you were in control. There's an affidavit produced from James Campbell, who was the director of operations for Gaithers. He submitted an affidavit that said she had nothing to do with the remodel. She had no control, authority, decision-making. She was not involved at all. And Ms. Gaither was just totally shut out from certainly March of 2013 for several years. And Gaithers ran this for several years. So Ms. Gaither has firsthand knowledge. Mr. Campbell has firsthand knowledge. They submitted affidavits. Also, in our brief, we reference interrogatory responses from Mr. Heatley. There's been extensive discovery in this case. There were 2 interrogatories that were served on Mr. Heatley. First, 2 sets of interrogatories. The first interrogatory I want to reference is he was asked to state the facts that he would offer at a hearing or trial to support his claims against Patricia Gaither for nuisance. Pretty straightforward to try to get the facts. His response begins, the first sentence is, Patricia Gaither was the wife of David Gaither until his passing, period. The rest of the answer is, these defendants, and he proceeds to talk about what they have failed to do. And that's it. So what facts do you have for Patricia Gaither? Here's what we have, that she was the spouse of David Gaither. There was a second interrogatory. Asked him to state the events and the times, how and when Patricia Gaither caused the Heatley's injury by nuisance. Again, the response begins, Patricia Gaither was the wife of David Gaither until his passing, period. Then it goes on for another 5 or 6 or 8 lines talking about the defendants and this alleged ongoing problem.
Does the mere fact that she had a marital ownership interest in this property become problematic?
No, it does not. And I would submit that there's a case that I cited in my brief. It's an older case, Grant versus Louisville and NR Company. It's a Supreme Court of Tennessee case in December of 1913. It is a case that really it is very analogous to this situation, in which case the railroad hired a company, independent contractor, to do some work on the property. The independent contractor did some work, located a work site near the road, which the work process eventually scared a horse that was pulling a car, a carriage, and the horse ran off and the person was injured. The railroad had no idea that they were going to do that there, what they were doing. So the court found, but they were sued. Obviously, the railroad was sued. The court found that the fact that a person owns real estate does not impose upon them the responsibility for nuisance thereon, and they can't be responsible unless they have knowledge of the nuisance, either actual or constructive. And in this case, they said the railroad did not have any knowledge that they were going to be at that location and doing whatever they were doing that day that scared the horse. I would submit that that is really what we're dealing with here. she was shut out. She was an owner, undisputed, but without more.
Well, she knew he was going to remodel the house and rent it, right?
She knew that it was going to be used. At that time, nobody knew of the septic system issue.
That came later.
And in fact, this case has been before the middle section panel before, and in that case, the findings of fact were that, yes, there was an implied easement for the benefit of the Gaither property. Nobody knew about it because the property had been under joint ownership since the 60s, I believe, under common ownership, and then at some point it was severed, and the tank was not discovered until October 30th of 2013, when Mr. Heatley contacted Mr. Gaither and says, hey, I found a problem on my property, and they got on it. Before then, nobody knew anything about it. So she couldn't have known it. David Gaither didn't know it. Gaithers didn't know it. So,
Let me ask you this, Counsel. After the tank was sealed, and that's with the supervision of the state, did you, in support of your motion for summary judgment, show that there could not have been any leaks from the septic tank after November of, I guess it would be 2014? What proof did you present concerning that?
in support of her motion, she presented not only the statements from Tennessee Department of Environment and Mr. Bradshaw, she submitted interrogatory responses, the deposition testimony of a real estate agent that represented the Heatleys. She introduced the property disclosure form that a potential seller is to fill out, and that form was signed by Mr. Heatley, and it specifically said that yes, the problem had been discovered, yes, the problem was corrected, and we would provide documentation to any potential purchaser.
But was there any expert proof that there was no longer any leaks?
There was.
From the septic tank after, was it November of 2000?
The new tank was installed in February of 2014. It was discovered in October 2013. By 2014, new tank was in, everything was cut off.
Right. So what was the proof about what happened after February of 2014?
The proof that she submitted was a declaration, from a septic tank installer named Shane Buck. Mr. Buck was contracted by my client to deal with the system. He went to the Heatley's property. He found several things. Number one, that the tank was in fact disconnected. He found that the tank was substantially empty, so it hadn't been used for a while. They also took out, Mr. Buck removed the piping from both sides of the tank, the outflow as well as the inflow, even though the inflow had been blocked. He removed the piping. He then dug up some soil and removed some additional piping on the outflow side. He also testified or stated in his declaration that there was no way. He discussed the design and purpose of septic tanks, how they're supposed to work, and he said that what they did permanently dismantled the system so it would not hold liquid, and the output lines were severed and blocked. He also opined and stated that when a septic tank is no longer needed, there is no requirement for it to be removed. What is required is that it can be, the tank is capped, and all lines can be left in place. They certainly could be removed, but they don't have to be. He stated that the lines were 3 to 4 feet below the surface, which were much lower than what is currently required, which is about 2 feet below the surface. And he said there was no need to remove the tank. There's no requirement. Just cut it off and leave it. It's been underground for, in this case, decades, just stop using it and leave it.
So
And-
he said there was no further discharge from the tank.
Correct, correct. And that was at the time he was there. And that was submitted in support of the motion for summary judgment. And we submitted that. The focus of the summary judgment was just that there was no proof that Ms. Gaither knew any of this, had any control, authority, influence. Two other points I want to make real quick.
Well, before you
Yes, sir.
move to that, let me ask you a question. Opposing counsel mentioned that he's asserting a continuing nuisance. Is that part of this appeal? Was that something that was litigated in this summary judgment as it relates to your client?
No. Well, they have always alleged continuing nuisance and talked about the damages. In the focus of the summary judgment, the chancellor just kept coming back to, as part of trying to establish nuisance, you got to establish that this person is liable for the nuisance. And the chancellor found from the facts, it was undisputed, that she didn't have any involvement with that. So if there was a nuisance, it relates to it relates to whoever may have caused it. But the question was, did she cause it? And there's no proof that that's the case. So
Who owns the property now?
the property that my client owned, it now is owned by a company called Generations Gaithers. That is a company that she owns. It, as part of this divorce case with her husband, they divided, she says in her deposition, which is introduced in the record, that they divided up companies. They had a number of locations. She received all of Generations Gaithers. He took all of Gaithers, Inc. And at some point, I believe it was in 2016, the license to operate the facility transferred from Gaithers, Inc. to Generations Gaithers. The Department of Mental Health approved Generations Gaithers because that was one of the properties that she received as part of this divorce settlement. And it was transferred in 2017, which was 4 years after discovery of the tank. And in sum, I would just submit that the record does contain plenty of undisputed facts that Ms. Gaither had nothing to do with it. There's precedent from the Tennessee Supreme Court, and I would ask the court to just affirm the findings of the Chancellery.
Thank you.
Thank you.
Your Honor, I'd like to address one thing raised by my colleague. Excuse me. And that is the issue regarding whether there was testing or anything to show that that tank had been actually secured and that there was no leaks. And I respectfully submit that that is not accurate, that there was no testing. They took efforts and they did perform some remedial actions when they disconnected the septic tank, but there was no new tank put in. That tank remained. The leach lines remained that were toward within feet of my client's property, and my client has maintained that this is an ongoing problem, that it was not remedied. They took actions, but it did not remedy it. But I'd like to bring Your Honor's attention.
Well, let me ask you, how did you meet their expert proof that there was no longer any leak from the septic tank? How did you?
Well, we did not submit expert proof to that fact, and at this stage, frankly, we don't have to, because Mr. Heatley was able to testify because they didn't raise the issue to the level to show that there was no condition. They did absolutely zero testing on my client's property to show that that condition did not exist any longer. Over the years, my client, and this was in the record prior but not raised at this time, has continuously had the property tested by the Tennessee Tech laboratory over there, and they found the excessively high levels of E. coli and other contaminants, and that's been throughout the case. That's continued throughout. We did not provide that again, even though we could have, but we didn't.
You didn't provide any of that in connection with your.
They objected to it at this level, that at this motion, they did object to us providing those. Mr. Heatley testified about the results that he obtained. They objected based on hearsay, but they didn't have any proof to shift the burden for us to even have to deal with causation or any of the other factors, because, and that's why that, frankly, we would submit was not important at that time, because they didn't negate any of the elements of nuisance. They didn't show that their remedial actions had been successful at any time in this case. Never have they. Ms. Gaither, and I'd like to point out, Your Honors, that in response to their statements of undisputed facts, number 11 and 12, they isolate the timing of Ms. Gaither and her stating that she had no knowledge of these things to 2012 and 2013, or 2013 and 2014. She focused on a limited period of time. This is an ongoing tort. My clients complained about it this entire time.
Well, but wouldn't you have to show a tort that occurred after the parties uncovered the tank? I think that's what the court suggests in the first case, that you have to show conduct that occurred after October of 2013.
Well, before
that, nobody was aware of the tank and the tank causing contamination.
That's right. And once they did, the state came out and said they had to fix these matters. They didn't. They took some actions, but there's no proof that what the actions they took were sufficient.
Well, they have the expert that says there's no further contamination after.
I disagree with that.
You disagree with the expert?
I disagree that an expert says that there's no contamination.
Okay.
I agree that they said, hey, we disconnected this, hey, we did this, but there's no proof in the record, respectfully, Your Honor, that it says that the contamination does not exist any longer.
Okay.
Let me ask you one question before we wind up. What claims remain in the trial court at this time? Are there other defendants?
As to what other defendants?
What else remains? You've got.
There's nothing else that remains. We just appealed the nuisance claim.
Okay.
That's the only one we appealed, one claim.
In other words, if we were to affirm the trial court, it would end this litigation except for what you claim, the ongoing nuisance. Is that correct?
Yes, Your Honor.
Okay. So there are no other defendants out there that have to be resolved?
No, Your Honor. We named, during the pendency of this action, David Gaither passed away.
Right.
We named the estate, and no estate was ever set up. And so we didn't set one up for him, and we just proceeded against Patricia Gaither, and the court's order dismissed the entire case.
The estate's not a party?
It's not.
And Gaither Inc. is no longer a party.
It's no longer.
Okay.
It was dismissed on summary judgment, and we didn't appeal that one.
Okay. Because
that company, in 2017, everything, the operating business was transferred over to Generations Gaithers in 2017, and that's who operates it through Ms. Gaither.
All right. Thank you.
Thank you, Your Honors.
Thank you, counsel. We appreciate your argument. We will review the record, take this matter under advisement, and attempt to get you an opinion at the earliest possible time. You may be excused. That concludes the call to the docket till the